and that ties in neatly with the next topic, Opportunistic Re-Incorporation. And this will be presented by nobody lesser than Luca Enriques. Luca taught and still teaches at Oxford. It is now has now moved to Milan, where he teaches at the Bocconi University. Luca is a frequent guest. We should rather, it's a bit self-gratifying or whatever. So we're always happy to have you here, Luca, and we're very interested in what you have to say on opportunistic re-incorporation.
Thank you. Thank you very much, Chris, for inviting me here, for allowing me to present a project that's still a work in progress. There is no paper. We only have a slides deck. And actually, I published an article in the Rivista delle Società last year, which will be the basis for this project, which, however, is joint. Which is joint work with Anne Lafar and Alessio Paces. And so we have 2 Italians and 1 Dutch legal scholar, because what we are doing is to look into the, we are looking into a phenomenon that has developed in the last 12 years or so. That is the migration by Italian companies to the Netherlands to exploit the greater contractual freedom that you find there. So I would also like to thank Chris for inviting me in this room today, because I love Vienna and its magic, and today the magic also shows into how slides breathe. I don't know whether you noticed, but it's very nice. So, no, there is no, okay. So, as I anticipated, there has been a wave of migration. It's not huge numbers, but we only have 200 something listed companies in Italy, and more than 10 moved to the Netherlands. Some in the occasion of cross-border mergers, others just for the sake of moving there, so that especially in this latter case, it's very clear that the driver is regulatory arbitrage. And so we look at these this phenomenon, asking ourselves whether it is a case of opportunistic reincorporation. These are all midstream moves in which minority shareholders may not have as much say as they would at the IPO stage. At the IPO stage, they can decide whether to buy or not, and they will set the price, and therefore the choice of jurisdiction or of ownership structure is fully priced in. Midstream, that's not necessarily the case, and this is reflected also in the US debate about corporate law competition. You are all familiar with the fact that Delaware dominates the market for incorporations and therefore the market for corporate law as a service. The debate was started in 1974 by William Carey with his article on the race to the bottom in the US, to which Ralph Winter, who was Roberta Romano's mentor, replied with a piece arguing that it was actually a race to the top, because you wouldn't choose a state unless your you could sell your shares at a high price, and therefore it must be the case that you go to Delaware because shares are worth more there. And there have been many voices in this debate. what I would like to recall here are two contributions by Lucian Bebchak. One from 1992, arguing that you should distinguish between reincorporations before a company goes public, in which case, again, you at the IPO stage, shareholders pay the right price, taking into account where the company is incorporated, against midstream reincorporation of companies that are already listed, which may lead to choices that are more favorable to managers than to shareholders, so long as managers somehow control the process of reincorporation. And Bebchak and Farrell, a little bit later on, made the point that there are some specific issues in which the interests of managers and those of the shareholders conflict when it comes to choosing in which state to be incorporated. Specifically, they argue that when the incorporation choice has an impact on the ability of managers to protect against the takeovers, so I'm putting in place defenses without any judicial constraint, for example, then that may lead to reincorporations that rather destroy value than create it. And we are still looking into the literature. There isn't much about how post the Google IPO, Google was now Alphabet was the first company in this century to go public with a dual class share structure. And many have followed, of course, especially in the tech and the media sector. We haven't seen much, but we are still looking into the literature on whether in the US the debate reflects the fact that when you have a controlling shareholder, you might want to choose the state that allows you to have the greatest freedom in deviating from one share, one vote. Perhaps there is not much there because Delaware allows all the freedom in the world to deviate from one share, one vote. So there is no reason to move away from Delaware for that reason. But at the same time, there might be, however, an issue with self-dealing. So if you are a controlling shareholder, you might want to go to the state that allows you to engage in self-dealing with the least control. And this is an area where there is a clear contrast between Delaware, which has quite strict rule, even though they were watered down, not coincidentally this year, on self-dealing compared to Nevada, which is the main, well, one of the two main competitors nowadays to Delaware. They have tried to build a position in the market for reincorporation for quite some years by basically, according to Bazuza, which shows actually what the rules are in Nevada on this, with rules that are extremely favorable to directors in case of derivative suits. So, because there in Nevada, basically, you are only liable for intentional misconduct, fraud, or knowing violations of the law. Delaware is somewhat more strict on this. And so there has been a move away from Delaware in the last few years by some companies. There has also been an important case, Palcom versus Maffei, which involved TripAdvisor, which has a controlling shareholder, Maffei, who doesn't have a great reputation as such in terms of fairness, but he chose to move to his company to Nevada, and he got a shareholder suit in Delaware, in which the plaintiffs argued that this was a conflict of interest transaction because Nevada's law would be more lenient with controlling shareholders, and therefore shareholders of TripAdvisor would lose protections and therefore would lose in terms of share value, the value of their shares, by moving to Nevada. Actually, the case was reversed by the Delaware Supreme Court, which noted that entire fairness, so the stricter standard that applies to conflict of interest transactions, would be applicable to a reincorporation case only if there is an actual situation of conflict of interest. So you already know that you will be sued, for example, and you want to move away to avoid the suit in Delaware. Whereas if it's just a potential suit in the future, then it's a business judgment that the board makes, and it's covered by the business judgment rule. So no review basically by Delaware courts. But still, Dexit, as it is known, is an important element of the US landscape nowadays, especially after Tesla's vocal move towards Texas after the Delaware Chancery Court invalidated Musk's pay package. It's interesting to note that Tesla moved to Texas and not Nevada, while other Musk companies that are not listed moved to Nevada. So he has some X and SpaceX are incorporated in Nevada. When he had to decide where to move the listed company Tesla, he chose Texas, according to reports, because he had to get a shareholder vote, and he has a de facto control over the company, and this is even disputed, but he doesn't control the general meeting. So he had to persuade institutional investors about the fact that it would be a good move, and Texas is less management friendly than Nevada in its rules, even though no one knows, as Matt Levine often notices, whether it will be indeed the case that Texas judges will be less pro-management, more pro-management than Delaware's. Anyhow, in order to get it passed, there was less, let's say, hostility to the move on the part of institutional shareholders with Texas as the destination. So that led to these changes in Delaware law. So this is the race to the bottom, if you wish, in action, because this year Delaware made 3 important changes to its law, 2 of which are reported in the slides, that make basically litigation less pro-plaintiff in Delaware, and with the explicit aim to avoiding further Dexit moves. So we now switch to Europe to note that there has been a case of regulatory arbitrage also in Europe, and more specifically a case of squared regulatory arbitrage, as I call it. It's slightly different from what Chris described at the very beginning, because it's all within the field of corporate law. And the second side of this regulatory arbitrage action is not something that you really can choose. It's something that you happen to be able to exploit, as I will explain. But still, so what these Italian companies did was to move their seat via cross-border mergers, usually, or transfer of seat, less frequently, to the Netherlands, because the Netherlands has more flexible rules on dual class shares. So basically, you can adopt different classes of shares without any maximum ratio, and you can immediately grant double or multiple voting shares to shareholders. And if you are a Dutch corporation, this move is only subject to a reasonable and fairness standard. More of this later. And there is there is no, this is something that we'll get more into the details on, but basically you can avoid the mandatory bid when you move from one vote to two votes as the controlling shareholders. And whether that is entirely consistent with the takeover bids directive is another story. So as I will say, the companies controlled by the Agnelli family were the first to move in 2013, and in 2014 was also the year in which Italy immediately tried to react, again with a reform that aims to avoid the escape from one zone jurisdictions to take advantage of another jurisdiction's laxer regime. So Italy introduced tenure voting, which was previously unavailable to listed companies. But it made it possible with a number of restrictions, like the fact that the mandatory bid would still apply, and the maximum numbers of votes would be 2. You would only get to have 2 votes after 2 years minimum, not immediately. And in 2023, there was an increase to 10 votes that you can get throughout 10 years. But and that was because in the meantime, corporate migrations after fiat continued. And so there have been more of them. What is the second element of regulatory arbitrage that is in place here? The fact that when you engage in these transactions which combine corporate migration with tenure voting, the Italian rules on how to do it are particularly lax. So these are not considered conflicted transactions because legal scholars in Italy are quite formalistic, and formally everyone is entitled to have 2 votes if they stay on for 2 years. So there is no unequal treatment on the books. It's just the fact that only the controlling shareholder chooses to opt for multiple voting shares that makes it unequal. In theory, if you change voting rights, there is an appraisal rights that dissenting shareholders could use to exit the company at a price which, however, is only the average of the previous 6 months, the market price of the previous 6 months. So you, as a controlling shareholder, you can look at the prices, and when you are at a point where the average is lower than the current price by a margin, you just do the transaction and no one will exit. It's extremely hard, even if you find a theory like abuse of majority position to attack the transaction. It's very hard to obtain a temporary injunction that suspends the transaction because the rules are stacked against plaintiffs, and the civil code makes it very hard. And since 2003. And finally, so it's hard to obtain a suspension, an injunction. And once the transaction is recorded in the company's register, it's too late. You can only get damages, but for a small shareholder, it's not worth the hassle to bring a suit for damages. And so it's very easy to exit Italy. And the reason why I call it a regulatory arbitrage, in a way, is that if you were a Dutch company, it wouldn't be as easy to move to a tenure voting from one share, one vote. In fact, while these loyalty voting schemes are not part of the Dutch corporate governance culture, which may well be a sufficient reason for why no one moves to tenure voting among Dutch listed companies, still it would be a more complicated move legally than it is in Italy. By the way, Italian companies are the only one, as far as we know, that have moved to the Netherlands for this reason, but not the only European companies that have moved to the Netherlands. There are other companies from Germany and other places that have moved there, but not to exploit tenure voting schemes, rather to use the Dutch rules that allow for board insulation against takeover. So other companies use these structures, which are more or less poison pills, the Dutch way, so that their boards will be able to fend off a takeover. The Italians do not even trust boards eventually. The Italian controlling shareholders want just to have control no matter what. They basically don't trust the board to make the right decision eventually. I'm not sure why Italy is the only place. I mean, I don't think it's corporate laws are worse than others in protecting shareholders from these moves. I don't think that Italian controlling shareholders are worse than others in exploiting private benefits. Of course, I'm not thinking about Austria, Germany, or France, but there are countries at the same latitude that are more similar to Italy, and it's unclear why then they don't exploit it. So I have some theories about that, but we can discuss them later eventually. So as I said, for a Dutch company, it would be much more complicated. While it is true that there are no exit rights under Dutch law, and it's also true that an absolute majority for the amendment to the charter would be sufficient, still minority shareholder can sue the company and subject the transaction to this reasonable and fairness standard test. They would also be able to ask the court to look into whether the transaction is in the interest of the company and whether it ensures equal treatment. And the enterprise chamber thinks of itself as the European Delaware Chancery Court. And so at least sometimes they are willing to review transactions in an active and non-formal way. In fact, we'll see later on one case of this kind. So to sum up, Italian companies have combined a reincorporation transaction with the midstream change from one share, one vote to de facto dual class shares in the form of tenure voting. And they have done so by taking advantage of the fact that the EU framework on reincorporations offers weak safeguards for minority shareholders. So it's like Delaware after the Delaware Supreme Court decision in Maffei. The details I won't go into, but they are in the consolidated directive. There is even almost nothing. There is literally nothing about controlling shareholder conflicts of interest in a reincorporation transaction. It's only about the managers, the directors' conflict of interest, Sondervorteile. And that's it. So if you are a director as a shareholder, you may have to declare something, but otherwise not. And in addition to that, there is flexible Dutch corporate law, and there is a very lax law in Italy about to ensure that these transactions are fair to minority shareholders. We are going to run some case studies. So the first case study, or case actually, is the DSM case in the Netherlands, in which the court approved, judged a dividend loyalty dividend scheme as consistent with Dutch law. The Supreme Court decided that these transactions are fine, which is what inspired lawyers of Fiat to extend the reasoning to tenure voting, to loyalty voting. schemes. And so the first mover within the Fiat group, then the Fiat Chrysler, Fiat followed, and Ferrari followed. It was a CNH Industrial, a trucks company that did this cross-border merger between two real truck companies. So it wasn't just a reincorporation, it was a merger between two controlled entities, two entities that Fiat already controlled, and in the occasion of a merger between the two, a loyalty voting scheme was introduced, which actually gave double voting rights immediately to all shareholders. So there was a doubling of votes for everyone, but you had to register in a loyalty register to gain the second vote. And in addition to that, you could also further increase your voting rights if you stayed on as a shareholder for another 3 years. But what happened was that basically only the Agnelli family and a few other used this option, and so they increased their voting rights from 30 to above 40%. And also there was no mandatory bid here because formally there was a new company with new shares, and the move from 30 to 40% took place before the shares were listed in the Milan Stock Exchange. So in that short period, they could avoid the mandatory bid rule. An interesting case is Mediaset, because Mediaset is the group of the Berlusconi family. They moved to the Netherlands in a situation in which they had a minority shareholder which originally wanted to be an ally of the Berlusconi family, but then they broke apart, and so they wanted to reduce the voting power mainly or reduce the governance rights of this minority shareholder, Vivendi, a French company. And so the deal structure was more aggressive than Fiat's. It also reserved appointment rights to some of the shareholders. But Vivendi sued, and it's interesting. Vivendi sued both. Sued in Spain, because there was a company there of the group that would be merged into the Dutch entity. It sued in Italy, of course, and it sued in the Netherlands, the destination state. And it got favorable injunctions in Spain and in the Netherlands, but not in Italy, to confirm that Italian rules are less pro plaintiff than elsewhere. And so the ruling was that loyalty voting shares are in principle allowed, but there has to be there is a question of whether the principle of equality will be complied with by the company, and it's not a clear-cut case, yes or no. So you will have to, in theory, each case the court will look into the structure of the transaction and decide whether it is consistent with the principle of equality or not. In the Mediaset case, the answer was no. Then the merger was reapproved on different terms, and it went through, and finally everything was fine. So it was in particular the combination between loyalty shares and director nomination schemes that was not in line with Dutch law, according to the Dutch courts. Last case is Campari, a recent one. This I only show you if you can read it, but I will tell you what those numbers say is that a small minority of independent shareholders voted in favor of the transaction, and it's actually always the case that minority shareholders vote no. In the case of Campari, there was a dominant shareholder which had also tenure voting rights according to Italian law, so he controlled the shareholder, the extraordinary shareholder meeting. It had 2/3 of the votes in that meeting, and therefore was able to thwart the transaction with its decisive vote. So this case, like all the others, with the exception of Mediaset, have not been litigated, so it's not clear whether the structures that are out there, the other structures, are consistent with Dutch law. And I'm almost done. I hope I'm not, I haven't spoken too much, but we would like to give some policy recommendations at the end of this paper. We think that this is a clear case in which, even though, again, formally, you may argue that there is no conflict of interest because everyone can become a double voting right shareholder, still there is a substantive conflict, and therefore majority of minority approval should be the rule for midstream deviation from one share, one vote, independently of whether this takes place together with the reincorporation. Perhaps there should be a veto power for independent directors, or a role for independent directors, which may not be determining of the outcome, but as we know from Delaware, it may lead to better terms for minority shareholders, because it's not just black or white. There are many shades of gray when you decide to go with stronger voice for controlling shareholders. I'm not sure whether it's possible to make appraisal rights that really work in order to dissuade this kind of reincorporations, but certainly the Italian rules are ineffective and could be improved. And finally, for midstream reincorporations, perhaps even in cases in which no conflict of interest is apparent, the idea that I came up with a while ago is that possibly a state should require its court to review the transaction according to the law of the destination state when it comes to the procedure as well, so that you cannot do something elsewhere that you couldn't do in that country. The intuition being that each jurisdiction has its own balance of rules, and if you cannot do something from within, then there's something wrong if you can do it from out with and exploit the fact that domestic rules do not apply. So I thank you very much in advance for your feedback and ex post for your attention.
Thank you, Luca. Let's jump right in. So I have Tim. Speak up and
the same phenomenon. We have approximately 10 NVs going to Wall Street, and they were basically all biotech companies, and we have 2 more specs. So this was a problem. Spec wasn't working. So that's our case. But I have one test case, and which is the Celonis. The Celonis is our biggest unicorn. It is worth 30 billion, and they are just considering to go to Wall Street, and they're considering whether or not to choose the NV. And the key points are completely different. It has nothing to do with the Bocconi case. So they're just considering with an NV. We don't have sunset clauses for dual class shares, which is very important for founders. That's the one asset. And we have one tier board, which you can't have with a German company. And the second thing is capital increase is much easier with the NV. And so they're just considering, shall we pick this? because this is much more expensive, or shall we pick the German corporation? And it's completely open. So the question is, the easy question, would there be a problem even if they pick an NV? There's a huge discussion, even hysterical discussion in Germany about countries leaving, being reincorporated in Dutch.
A problem for whom?
Yeah, this is my question. Is there any problem with that for German politicians and for Frankfurt maybe, or well, the answer is maybe a problem for German law firms?
Yeah, that was about to be my answer. Yes, it's a problem for those who provide corporate law services. It can be a problem for the stock exchange if the listing takes place in the US, but that's not that has nothing to do with the choice of the NV rather than the AG. So that's another story. If it's all pre-IPO, there is no minority shareholder protection issue, so I don't see that. It's about the competitiveness of the German Finanzplatz, if that's the name, because it's an ecosystem, and if you have less work for lawyers, then you have a weaker ecosystem, I would say. But other than that, no.
Mm-hmm. Yes, Alperin. And then I have Mr. Fuchs.
So very briefly, Tim, I would also say it doesn't matter for the real economy of Germany, because Germany is not Delaware. It doesn't depend on franchise tax, I guess. So that's my 2 cents on that question. But my question to Luca is, so under cross-border mergers directive, I guess all these reincorporations to Delaware, you said through cross-border mergers directive or conversion. Isn't there a mechanism of exit rights, mandatory exit rights for minority shareholders under that directive? And isn't that an effective actually protection? Because you said all these minority shareholders actually vote no, and they get actually a mandatory exit right. So if they don't like the transaction, they can exit, and they would get evaluation from the court on their on the value of the shares, regardless of the market price of the share, I guess. So isn't that an effective mechanism?
Exactly. If I can add to that, there's also this this prohibition of abusive reincorporations in the very same directive. Do we have to take you as not putting too much trust into this abuse control? Because technically it would be for Italian courts as the exiting country to either allow or not allow reincorporation in the first place, plus appraisal rights. Yeah.
Great question. So yes, so there are these exit rights, and Italian law implementing the directive had to provide for specific rules other than those that apply for other changes, because the criteria are different for the pricing of the shares according to the directive and according to Italian law. However, while for the Italian rules, it's extremely clear that you can go around them and not worry because of the pricing mechanism. Still, this is a decision that is made by the controlling shareholder, and there is no one that knows the company and its prospects better than the controlling shareholders. And unless you have a case law that somehow finds a way to find a price that is much higher than the market price, then it will be easy for the controlling shareholders to know when is the best timing for the transaction. It will be the time before breakthrough or whatever is announced, months in advance, of course, otherwise it would be too suspicious, but they know how things are going. It's the same with the delisting decisions. They are always conflicted transactions, or they are always insider trading transactions in a way, even though they are totally legal, because the insider knows that the company is valued less now than it should, or than it will be in the future. So I don't think that's enough. As you said, Chris, yes, abusive reincorporations are not are something, but as you said, it's the exiting jurisdictions that decides on that, and you need quote unquote activist judges to find that this sort of transaction is abusive, but it's a point we have to be explicit about. So thank you for, and thank you, Alper, and also for pointing this out.
Dr. Fuchs.
So my question is to you. Thank you for your presentation, firstly. Normally, you have big problems from the tax side if you transfer to other countries, especially in the EU. Can you, only if you know it, of course, because you're a corporate law specialist, what were the problems with the taxes there?
You mean exit taxes?
Yes, for example, exit taxes.
So as you said, I'm no expert in tax law. Perhaps Tim can help us on this, but my intuition is that these transactions first of all, I don't think a pure reincorporation has such a big effect on where you pay taxes. That's what I've learned from reading here and there, because you pay taxes where you make profits, and therefore, in the case of Fiat as well, they made actually the choice of London as the seat for tax purposes of the headquarters, but that is just because, at least at the time, London had favorable rules on share buybacks, basically, and they were not taxed as dividends, or there was a tax treatment that was not exactly the same, and so that was the choice that was made, but there was no issue with exit taxes as far as I'm aware. It's also dealt with in the tax cross-border merger directive, but don't ask me for the details.
So you get this advantage from the corporate law without paying taxes. This is what you think.
Sorry,
you get obviously you get disadvantage from the corporate law without paying taxes.
Without tax disadvantages that are at least bigger than the corporate law advantages. Otherwise, they wouldn't do it, of course.
I mean,
thank you, sir.
If I can maybe expand on this. So before we had this protected scheme, you would need to basically liquidate and reincorporate. And for example, then hidden reserves and everything would be taxed.
Yes.
So the part of the charm of this entire scheme, which we've built up first from freedom of establishment and ECJ case law, and now into the reincorporation directive, is precisely to identify non-taxable events, which reincorporations really are as the heart of the matter. And is this all from the auditorium? Then can I just pick you up on one little thing, because I found really interesting this observation you made on like a hypothetical. So the Italian courts, you're saying, should look at this from a Dutch perspective and should not go beyond what would be possible in a hypothetical setting in the Netherlands. This leads to something that I suspect may be one possible solution for many of these arbitrage decisions. It's the conflict of laws, because conflict of laws has solutions to precisely this. What you formulated is foreign court theory and things like recharacterization. Let me give you just one little example. If you have a contract that is subject to US law, say, or to English law for that matter, and you are arguing before Austrian courts, it seems as if claims from that contract are never prescribed. It seems as if there's no statute of limitation, because the applicable contract law does not have statute of limitation, and neither does the applicable Austrian civil procedure law. And the way that conflict of law has been going about this is recharacterizing it. And the first intuition has always been by switching around and combining legal orders, there should be a limit to the opportunistic advantages we can get from this. One opportunistic advantage that should not be permitted is unprescribable claims, for example. Okay, so there is doctrine and theory in the realm of conflict of laws on precisely these types of questions. just as a.
Thank you. No,
yeah.
that's a nice thing to go into. Our proposal was much more modest. That is to change Italian law, the civil code, and provide it without any doctrinal input. But also because the judges would never accept it. And you, I'm not sure it would be harder to pass the test of whether this is consistent with the directive, but there would be that question to answer. I think it's not in violation of the directive, a policy of this kind, but it's another issue that may have to be looked into.